Is everyone seeing my slides okay? Great. Thank you all for joining today. I thought it might just be helpful if we put in the chat who we are so we kind of know who all is here today. I know this training is geared at COC and ESG funded providers or anyone else who has kind of VAWA compliance language in their housing provider contracts. But just might be nice to know who's on the call. This is a dense training with a lot of material. So I just want to let you know in advance that you will be getting the slides from this training, and it'll have links to all of the forms that we're going to be talking about today. But this is really supposed to be helpful for you all as you implement VAWA compliance. So I'm hoping to give you some practical advice on that, but please just interrupt me as needed to ask questions or interject if you feel like clarification is needed. Or if you want to talk about how your local process works or your plan works, things like that, we can do that too. So depending how much time we spend talking during the training, there might also be time for questions and discussion at the end. I have the objectives for today up on the screen. So I thought I would just talk about for a moment who this training most applies to. So definitely anyone running or working for a project that has COC or ESG funding. There's also a lot of relevant information about anyone who's assisting with unit location, lease negotiation, landlord engagement. There's some information about that with VAWA compliance too, again related to COC or ESG funding. Really anyone working for a coordinated entry project, as the coordinated entry system has to get involved with some of these issues. And then anyone working in a role that denies people assistance or admits people into programs. So that might be intake people, things like that, as we talk about the notices that are required during those times. Okay, so the first thing we'll do is talk a little bit about the Violence Against Women Act and kind of the general federal regulatory landscape. So we're going to talk about VAWA just briefly and then how it applies to HUD, but we'll talk about what it is, some historical context, and go over some definitions that'll guide us today. All right, so a lot of info on this slide, but the Violence Against Women Act is landmark legislation that was passed in 1994. It's been reauthorized at pretty regular intervals. The last time it was reauthorized was in 2022. So every reauthorization, generally we see VAWA get stronger and broader. So the historical context for VAWA is that it really was passed in recognition that domestic violence is an epidemic and that a federal response was necessary. So the provisions are really, really vast. So today we're really just going to be focusing on VAWA's protections for survivors in HUD-funded programs. And so HUD did issue a final rule in 2016, specifically about how it expects its projects to comply with VAWA. So really the kind of ideals behind HUD's final rule as it applies to VAWA is that everyone should have a home that's free of violence and that our communities should work to decrease the homelessness caused by domestic violence. Um, so that's just a little bit of background. So who does VAWA protect? I'm going to go into the definitions for each of these, but VAWA provides protections for survivors of domestic violence, stalking, dating violence, and sexual assault. And something that's pretty important to highlight here is that even though it's called the Violence Against Women Act, of course, VAWA is not just about providing protections to women, right? It protects survivors regardless of their sex, gender, race, national origin, sexual orientation. Um, and I'll keep reminding you of this as we're discussing forms and policies. But HUD did put out kind of new forms and policies in 2025. And this statement here about how broad of protections that VAWA provides was taken out of a lot of those forms. These are just model forms. So as you go through and update your own forms and policies, you can add this statement back in. So HUD has now put in all of its forms that VAWA applies equally regardless of age, sex, or marital status, and that's where they leave it. But that doesn't mean that the actual final rule has changed. It still applies, of course, regardless of sex, gender, race, sexual orientation, everything you see on this screen. So just highlighting that you might see that caveat missing from current model forms, but that it still applies. And you actually still have it in your local governance charter when talking about emergency transfers, which is great. Um, just a couple of additional things to know. In order to get VAWA protections, the person doesn't have to have a perpetrator that has been convicted of a crime for them to be considered protected. And VAWA also protects people that are affiliated with survivors, so children, spouses, siblings, parents, anyone residing in the home with the survivor. So just trying to interpret this as broadly as possible. So very long definition here, but VAWA has its own definition for domestic violence, and then I'll go through the next three definitions too, and I'll be showing you those definitions as well. But I think the main thing to note is that the definition of domestic violence under VAWA is super broad, it's long, and it covers a lot of different interpersonal situations. So we don't have to be interpreting it in some of the more narrow views that people often think about domestic violence. So the definition that you see on the screen was updated during the 2022 reauthorization. The main update that I think is important to discuss is that it did add this economic and technological abuse to the definition, and then it also added definitions for those terms as well. So I think that's the main difference to point out. Here are VAWA's definitions for dating violence, sexual assault, and stalking, which are defined here on the slide. And we're just going to use the term survivor a lot today. That's what HUD uses in their materials. And that's meant to really just be broad and all-encompassing of these definitions and the domestic violence definition that we showed you. So I'll put, for interactiveness, even though it's an easy one, I'll put in the chat here just a little poll. Can you all see that? Okay, so it says, who does VAWA protect? And there's lots of answers here. So it looks like people are catching on that even though it's called the Violence Against Women Act, it's not meant to protect just women, which was the kind of important part of these slides. So that's great. Okay. I want to just talk a little bit more about the reauthorization of VAWA, and I'm going to put a link in the chat to the letter that HUD sent out, very specific to VAWA compliance and this reauthorization, just so you have it, but it's also going to be linked to in these slides. So there was a lot of changes in 2022, and I'm just going to cover the most important ones for our projects today. I'm sure that most of you saw this during your HUD COC NOFO. But in 2023, starting in that NOFO, HUD added this new line item, a new budget line item that you can include in your COC funded projects so that you can actually have a specific place to charge for any VAWA related compliance work and any work that you're doing to support the emergency transfer process. So hopefully your collaborative applicant can provide more information on that during NOFO time if you're thinking that that's a budget that you want to add to your COC funded project, or you can probably grant amend and add it to in an off cycle. So the other thing that the reauthorization did was add protections from retaliation for people who are exercising their rights, which hadn't been in there before, surprisingly. It also added a section that said that landlords, tenants, and others can't be penalized for seeking assistance from law enforcement or emergency services like EMS. So this is basically a direct response to some of the crime-free ordinances and nuisance laws that have been being passed that were pressuring landlords to evict people who frequently called 911 or other entities asking for help. And so this actually applies to all housing providers and not just those usually covered by VAWA. It was meant to provide broad protections. I don't know if this is still the case given everything going on, but in this letter that I put in the chat, HUD did say that they were going to increase their VAWA compliance monitoring and spend a lot more money on it and really make it a priority. So, you know, just encouraging folks to work on their compliance there. The other big thing that the 2022 reauthorization did that's probably the most important change for your COC and ESG funded projects is that it updated HUD's definition of homelessness. So for COC and ESG projects like transitional housing, rapid rehousing, for coordinated entry, right, we're using HUD's definition of homelessness to determine who's eligible for our projects. I'm sure most of you know there's 4 categories of homelessness that someone can meet to fall under HUD's definition of homeless. And the fourth, which we often call category 4, is that people who are experiencing domestic violence with no other safe residence or resources to obtain permanent housing, those people meet HUD's definition of homelessness. Um, and so people who meet this definition are eligible for mainstream or non-DV specific homelessness resources, right? That like COC and ESG programs provide. So the italics that you see on the screen are actually the updates to the definition that were made to the category 4 definition. It used to just start here with the word fleeing. So it's really important that you update any eligibility documents that you have that talk about the definition of homelessness to this new definition. As I say that, I will say that HUD has not updated its website with this new definition as far as I saw. So it does get a little bit confusing if you go on the virtual binder and look for the definition of category 4. It still has the pre-22 authorization definition, but this is the final definition for category 4. So good to update those forms. The last important thing I want to talk about for the reauthorization is that HUD created its own web page for VAWA complaints. So if people feel like the rights that we're going to talk about more today have been violated, they have this new HUD website that they can go to read more about recourse for that. I just put that website in the chat. Um, and so right after the reauthorization, HUD actually made its own VAWA specific complaint form, which was really cool. Now, the complaints after you go to the VAWA specific website just go back to the general fair housing complaint website, which is, a little bit disappointing. We were excited to see that VAWA specific complaint form for a while, but that doesn't mean that clients can't still come to this website to complain if their rights were violated. You just may need to walk them through it a bit more. Because as you'll see here on the screen, I kind of screenshotted the form. There isn't a section anymore for VAWA specific discrimination, and you'll have to click that other reason box there. So another thing that the authorization created that's neat, right? Its own pathway and portal on the website, but then, you still have to use this kind of general complaint form now. Okay. HUD also creates model forms to help projects like yours comply with VAWA. And so, you don't have to adopt the model form exactly as they are, and we'll talk more about that. But after the reauthorization, HUD decided to put out changes to the model forms, and that was in 2024. They asked for 30 days of comments from the public about, the forms and things that they wanted to see changed. Then in April, I think, of 2025, they updated their website with all of these new forms. An announcement did not go out over HUD Exchange. You just kind of had to stumble upon them to find the updated forms. And I'm not sure how many COCs have noticed that the forms have been updated, the model forms, but that's kind of why we're doing this training today too. So we haven't gotten any implementation guidance from HUD about the forms or anything, but I'm still going to cover today the new model forms. A lot of them seem to be a lot more clear and provide clarity, are shorter. So it's worthwhile to look through those and decide whether you want to update any of your forms with these HUD model forms. In case you're using some of the older ones. So as I go through each form, I'll put the link in the chat, but there are also links to the forms will come in this presentation. So see here. All right. So one thing I wanted just to say too about the forms quickly before we go on to the VAWA rule is that in the previous model forms, HUD had translated the forms into 15 different languages. Those have been taken off of the HUD website. And each form that they have put up on their website now, the model form, does say that you need to provide the form in the language that the person needs, but there no longer are those translated forms on the website, at least that I could find, even with the links in the forms. So as we go through that today, I'll try to point that out, but that's just a little bit of a reminder in the background that the onus is kind of now on housing providers to provide translated forms and notices. So we're not going to talk about just VAWA generally anymore. We're going to talk about very specifically the final rule that HUD has implemented in order to be compliant with VAWA. Um, so again, this mostly applies to COC and ESG funded programs, but of course, VAWA compliance can be part of people's contracts and things like that as well. So just important to know. So these are the things we're going to cover in this section that we kind of consider the key safeguards that are included in this rule. So there's housing protections, there's a requirement to have an emergency transfer plan, and then there's some notices you have to give out and some contract terms you need to put in leases. So that's really what this section is about. So these are the core housing protections that are in the final rule for people under VAWA. So this section covers the rights that COC and ESG projects need to ensure that clients know that they have. So survivors can't be evicted or denied housing solely because of their status as survivors. And they also can't be evicted or denied housing based on factors related to that victimization. So what this is really trying to get at is helping to mitigate or offset some of the kind of financial or social harms that happen during domestic violence, and kind of acknowledging that domestic violence isn't just about physical injury. It's about all the ways that it makes it hard to kind of leave and become independent and the other kind of lasting impacts that it can have. So that's why they have examples here of other adverse factors, right? And have added those economic abuse and technological abuse definitions. So lack of credit, lack of income or employment history because someone wasn't allowed to work or have access to credit cards, things like that. So really trying to make this broad. Just because someone does have VAWA protections doesn't mean that they can never be terminated or evicted from a project. So kind of standard lease issues or violations that are not based on domestic violence can still be, handled through the termination or eviction process. So the standard really is just to make sure that the tenant isn't being subjected to a more demanding standard when you're trying to figure out whether they would otherwise be someone that you would terminate or evict from your project. And so just really making sure that we're removing any discrimination potential for survivors and making sure that they're just being held to the same standard as everyone else. The other time that someone can still be evicted is if the housing provider demonstrates an actual and imminent threat to other tenants, employees, and service providers. And so you'll see here that they want to be really sure that this is an actual and imminent threat. So they've defined that here pretty closely so that people can't just kind of use it generally. So in order to evict someone because of the fear of domestic violence, is that there needs to be a, severe potential harm, a high likelihood that the potential harm is going to occur, and things like that. So we need to not make this based on stereotypes. The claims have to be real. They have to be real concerns related to this tenant and that you're really fearing for your, say it's an on-site project, your on-site case managers, your on-site employees, and that you feel like that's a reason that the person needs to be removed from the project. So we can't just be saying just because we know domestic violence is happening in the unit and all DV becomes a danger to others, something like that wouldn't be an actual and imminent threat. It would need to be a lot more specific to that. Does anyone have questions about that? So really the goal of HUD's final rule as it relates to VAWA is that they want to be sure that we're not causing people to lose their housing because they are experiencing domestic violence. So that's really just kind of the undercurrent of this all. So we're working really hard just to prevent the loss of housing, to take a flexible approach, right? And to figure out how to support people and using eviction and termination as a last resort, just so that we're, preventing additional housing related harm to survivors. So really, we're hoping that people can try transferring people, barring the perpetrator from the property, contacting law enforcement, and other legal remedies before we're kind of getting to that need to evict or terminate based on actual or imminent harm, which I imagine you're all doing. I'll do another poll here now. Okay, can you all see that? So this is a question about people's VAWA rights. A client is working with a victim service provider to find housing. The landlord infers that there's a DV situation and decides not to rent to the client as they worry someone could come to the multifamily property looking for the client, and that might cause a scene or a nuisance. Is this a violation of the client's VAWA rights? Seeing 5 respondents. I'll give you a little bit to think about this. So it looks like most people are putting yes. I think that's right. Survivors can't be denied access to housing solely because of their status as a survivor. So the mere fact that this person is a survivor doesn't mean that there's an actual or imminent harm that's present. Okay. I'll do one more here quickly. All right. A survivor of domestic violence does not pay their rent for 3 months, and they have a dog in the unit without landlord permission, which is against the lease. Is it a violation of the client's VAWA rights to serve the client with a 3-day notice to cure or quit? Okay. Looks like most people are putting no here, which is the right answer. So survivors of domestic violence can still be evicted for lease violations, of course, that are not based on an act of domestic violence. So that gets into, again, kind of the limitations of the rights that we were talking about. Okay, we're going to start talking about emergency transfers. So when I showed you kind of those 3 key safeguards, the first one was the core housing protections, which we just covered. And then the next one is emergency transfer plans. So I'm hoping that this section will provide you some really practical advice for your COC's emergency transfer plan and for the housing provider emergency transfer plans. So that's kind of the goal of this section here. So what is a VAWA emergency transfer? This is kind of a broad definition here about the COC and housing provider's obligation, but essentially each COC, per the interim rule, must establish an emergency transfer plan, which is defined on the slide here, to quickly relocate DV survivors receiving COC and ESG funded assistance. You'll usually find this plan in a COC's written standards or governance charter. And so a VAWA emergency transfer quickly relocates survivors receiving assistance who believes there's an imminent threat of harm from further violence if they remain in their home or if they were recently sexually assaulted in their home on the premises. I guess on the premises is the same as in their home. So who qualifies for an emergency transfer? Before we're going to talk about all of the different types of emergency transfer requests and what's required to be in an emergency transfer plan, I just wanted to start by talking about who qualifies to request an emergency transfer. So someone can request that their housing provider transfer them to a new unit if all of these first two conditions are met, and then one of the second two. So if they're a survivor of domestic violence, dating violence, sexual assault, or stalking, they expressly request the transfer, and either they believe there is a threat of imminent harm from further violence if they remain, or if they're a survivor of sexual assault and the sexual assault occurred on the premises during the 90-day calendar period preceding the date of the request for transfer. So pretty specific eligibility criteria here that is covered under the emergency plan section of VAWA. So these are the clients that you would have to review their request to determine if they would be approved for an emergency transfer request through your plan. And this is who should be approved and who has the rights to an emergency transfer under HUD's final rule related to VAWA. So if someone meets the eligibility that we just discussed, they can request different types of emergency transfers. And so this is a quick review of those types, and then I'll have a slide for each one. But there's internal emergency transfers. So maybe the participant wants to stay with your agency, but meets the requirements of the eligibility of an emergency transfer request, and wants to move units. So that would kind of be internal. They're not a new applicant to your agency. They're just moving locations. There's also an external transfer where someone would move to a totally new project, a new agency where they would really be kind of a new applicant for that project. And really the participant can decide. It also, of course, is going to just depend on what units are available. And so the participant might be clear that they really want to stay and only ask for an internal transfer. They might only want an external transfer. They might want whatever comes up first. That's really going to be something to work out directly with the client. Probably the most important section on this slide is about a safe unit. So everywhere you'll see that HUD says we need to transfer clients to a safe unit. And this has a very simple definition, which really is just defined as a unit that the survivor believes is safe. So really just trying to center that in what a safe unit is. So a simple but broad definition there for safe unit. Okay, so an internal transfer process, depending on the type of transfer being requested, kind of governs what steps you'll need to take. So if they want to move internally within your agency to a different unit, you're expected to take kind of immediate steps to transfer someone if you have a safe unit available, and you might not. But if you do have another unit available within your agency, within your project, that the client feels is a safe unit for them, you are expected to try to make that transfer once you've approved it as soon as possible. There is still a role for coordinated entry in an internal transfer. So I'll talk about kind of coordinated entry's role generally as we go through this, but since all COC and ESG funded beds are filled through coordinated entry, we still recommend letting coordinated entry know when you're completing an internal transfer. And I'll talk more about confidentiality and like what you need to tell them in a little bit. But I think it's a good practice to tell them that you have filled an open COC or ESG funded bed with a prioritized internal transfer. You don't even have to say that it's an emergency transfer. Because I know that sometimes COCs track coordinated entry compliance. They look for kind of like backdooring of clients. Sometimes it's a NOFO scoring factor where people pull coordinated entry data and look at, did you only take people referred from coordinated entry? And so during the transfer, it can look like you just put someone in that open bed internally. So it can be a good idea just to let the coordinated entry system know. And if you're worried about your case file compliance and showing that you used coordinated entry to fill that unit right, you could put that notification in your case file too, along with the original match form. So just some practicalities of the internal transfer process to consider is that it's even though you don't really need coordinated entries help to move the client to an internal transfer, a new unit of yours, it's good to still notify them of the transfer. Uh, when you receive an internal transfer request, your policy should state that these requests are receiving at least the same priority as other types of transfer requests. So you may have another prioritization that you use internally when clients want to move units that helps you decide when to implement those requests. And so these internal emergency transfer requests should have at least the same priority as all of those other transfer requests. So if the safe unit is not available within your agency or your project, the participant should be offered to either wait until a safe unit becomes available. So if they only want an internal transfer, that might be the only option for them. They can request an external transfer, and you can then work with the coordinated entry system to find them another unit outside of your project, or they can do both at the same time because there might not also be an external transfer available. And so it could just be whatever comes up first. An external transfer process is mostly the same, except it relies a lot more on the coordinated entry system. So your COC's emergency transfer plan you might consider updating it more with more details about what your local process is for external emergency transfers. But typically for an external transfer, you need the coordinated entry system to facilitate the referral of the participant to the next available safe unit that they're eligible for through the coordinated entry system. So um, your coordinated entry policies and procedures, in order to be compliant, should have a prioritization that states that the participant that has been approved for an emergency transfer has priority over all other applicants for the beds for which they're eligible. So essentially, if someone is requesting an external transfer from one project and they're in a PSH project, if the coordinated entry system has an open PSH bed that they were just about to refer someone to on the community queue, the person requesting that emergency transfer would actually, if they're eligible for PSH, would have that prioritization for that bed. And then, potentially the person that was about to get a referral to that bed takes their vacant unit once it gets reported to the coordinated entry system. So in some cases, no net loss of beds, just a different assignment of beds. But that's how the prioritization is supposed to work, and that's why the coordinated entry system needs to be involved, is really only they can make that referral and do that prioritization for an external transfer. Does anyone have questions on that? Okay. So I think everyone probably knows that HUD does allow for PSH to PSH transfers. That can be confusing sometimes since clients technically don't retain their chronically homeless status while they're in PSH, but HUD has been very explicit that so long as they don't start to experience homelessness again in between the two PSH projects, if they're just being transferred from one to another, they are retaining their eligibility and that's fine. So this kind of puts everything together that we talked about a little bit about how the entire kind of model emergency transfer process should work. So COCs and housing providers, when they're making their emergency transfer plan, right, in this orange box, are deciding how they want their emergency transfer request to be submitted, and we'll talk about the forms that you can use for that. Whether they want those requests to be in writing to the housing provider using HUD's model emergency transfer request form, whether they want some other written process, or that it doesn't have to be in writing. So however the COC or the housing provider decides that they want the emergency transfer request, that's how they'll receive the request for the transfer. They'll determine if the person qualifies using that actual imminent harm or 90 days eligibility that we talked about previously. Um, they will notify the coordinated entry system, so either letting them know of the internal transfer or requesting an external transfer or both, and then they'll pursue whatever transfer type to a safe unit is available. I will put another poll, I think, here in the chat now. Okay, hopefully you all can see that. It says, who has the ultimate say in determining what a safe unit is? So we have the survivor, the landlord, the housing provider, and the COC's coordinated entry system. Okay, so the correct answer here is the survivor. And so the COC's coordinated entry system is, I can see why you would think that, right? Because that's who is supposed to make the referral, and they might only have certain referrals to make, so they're responsible for the actual referral for that unit, and then the survivor needs to decide if they consider it a safe unit or not. And as we all know, there's not tons and tons of openings all the time. And so sometimes, unfortunately, there may not be a ton of options. There might only be one open bed at that time that the coordinated entry system would have. So, okay. And then I'm going to put up another one. Oh, here it is. Sorry. Okay, this one says, in which of the following cases does someone in a COC or ESG permanent housing project qualify to apply for an emergency transfer? The client is a survivor and lives alone. They believe there is a threat of imminent harm from further violence if they remain in the unit. The client is a survivor and lives with a partner. They believe there is a threat of imminent harm from further violence if they remain in the unit. The client is a survivor and wants to move to a permanent housing unit closer to their child. The client experienced a sexual assault on the premises during the 90 calendar day period preceding the date of the request for transfer. And it's a select all that apply question. Hey, you all have it right. So the first two and the last one are all meeting the requirements that the person, be a survivor of domestic violence and either believe there's a threat of imminent harm or have the 90 calendar day eligibility in order to be eligible to request an emergency transfer. Just because someone is a survivor of domestic violence doesn't mean that they're automatically eligible for an emergency transfer for another reason. There needs to also be that element of imminent harm or the 90-day eligibility criteria as well. And then I'll do one last one for this section. So this one says, a client was literally homeless for 30 days, then in a shelter for 30 days before entering a COC-funded rapid rehousing project. The client qualifies for an emergency transfer and makes a written request for the transfer. The only open bed that the coordinated entry system has is for a permanent supportive housing bed. Does the client get prioritized by coordinated entry for this referral since they have requested an emergency transfer? Hey, so this one is a little bit of a trick question since I'm also showing the slide that says they need to be updated with a prioritization for emergency transfer requests. But really people get that prioritization only for the units for which they are eligible. So because this person doesn't meet the definition of chronically homeless, because it looks like they were only homeless for about 60 days before entering their RRH project, they still don't have eligibility for a permanent supportive housing project. So they will need to wait and be prioritized for the next bed that's available to them for which they are eligible. Does anyone have questions about that? Okay. Okay. So we went over kind of the details of how the emergency transfer plan should work. And so we're going to talk now about what your COC and what your housing providers need to do to make sure that the actual processes that you have in place to implement everything we just talked about, are compliant. These are the things that your emergency transfer plan has to have within it. You need to have details about the transfer process. You need to outline that eligibility we discussed. You have to make decisions around what documentation that you want to require, and we'll talk about what you can require. You need to talk about confidentiality protections, which we'll also talk about. And then you need to talk about what happens to non-transferring family members, which we'll also talk about. Your emergency transfer plan needs to be made available not only to the people in your project, but also to the public. You do have to keep a record of all of your emergency transfer requests and the outcome of those requests for 5 years, and report to HUD. And there's no limit on the number of emergency transfers that can be requested. So I'm going to dial in now on this keeping a record of transfer requests because this is something new from HUD. When those model forms appeared on the HUD website this year, there was a new one added that we had not seen before, and I'm going to put it in the chat in case you want to look at it directly. It's this 5384 form. So HUD has created this new model form this year. And really, since we don't have implementation guidance, this is what I think it's for. It indicates that HUD is going to start asking COC funded recipients to respond to data requests about emergency transfers, potentially using this form. In order to start monitoring VAWA compliance. So again, I haven't seen this form be used yet. Maybe some of you on the call have submitted a SAGE APR recently and could tell us if this form was part of that process. But at some point, we should expect that this data request form will be sent to COC funded providers. And so kind of a goal today is to let you know that you should have a record keeping procedure for your emergency transfer requests. And it should align with the data inputs that HUD is asking about on this form, so that you don't have trouble responding to this form should HUD start using it at regular intervals or as part of its annual SAGE APR reporting process. So the form that I just put in the chat basically asks you, is your emergency transfer plan public as a housing provider? If it's not, why is it not public? And if it's not, they want a copy of it. They're also asking you how many emergency transfer plan requests did you get during whatever reporting period they're going to use this for. So far we don't know. I'm assuming it'll be for a year period of time or for the length of your contract period. And they also want to know how many are pending from other reporting periods. They want to know how many emergency transfer requests were incomplete. So maybe you approved it but didn't complete it for some reason. And they also want to know how many you denied. And they give you a checklist for why you may have denied the request, right? Like maybe someone didn't meet the eligibility that we just discussed. They also want to know how many of the emergency transfer requests that you actually approved were internal versus external. And then they want to know how many emergency requests did you approve and actually then complete. So you said, yes, you are eligible for an emergency transfer. But then did you complete the request by actually transferring them internally or externally? And if you didn't complete that, then why not? And they are also giving you a checklist there of reasons why you may not have been able to transfer them. Like maybe you couldn't find a new unit, nothing came up in the coordinated entry system, etc. They also want you to be keeping timelines of how long it took you to approve or deny an emergency transfer request. And then if you did approve it, how long did it take you to actually complete the request? So a pretty big data and record keeping item here, and something to work through with your staff about like how you would potentially respond to a data request like this from HUD if they start using this form. This is a pretty new thing, so I'll just pause there to see if anyone has questions. Okay. So we talked about emergency transfer plans, and HUD does not want you to be alone and on an island trying to develop an emergency transfer plan that is compliant. So I'll put in the chat their new updated in 2025 model emergency transfer plan document. They've created this model emergency transfer plan for you, and it outlines everything I just went over in all of the slides. So it very clearly outlines who's eligible for an emergency transfer. It talks about the definition of a safe unit, about internal and external transfers. It talks about all of the VAWA protections and rights that people have. But they don't do everything for the housing provider. There's still edits that you need to make and decisions that you need to make as an agency. And so HUD says that you can't just take this form and basically like put it in your policies without making edits to it. Um, so I've gone through some of the kind of practical decisions that you'll need to make as a housing provider when figuring out your emergency transfer plan or updating it to align with this model plan. But even if you're pretty happy with how your plan is working for you right now, it might still just be worth going through this plan and seeing if it has anything in it that you want to add to update your plan, or maybe ways of explaining the emergency transfer plan process that in a way that's more clear than your current process, things like that. So some of the practical decisions that they're asking you to make in this emergency transfer plan is they want you to put in some timelines for how long you have to approve or deny a request. So if you get a written request from someone for an emergency transfer, like what are your staff timelines and guidelines for how quickly they need to get back for to the person? Um, they want to make sure that you have it in writing somewhere in your policies that you're granting, priority for internal transfers, the same priority at least as you're giving other requests. Um, and they want to be sure that you're allowing internal transfers when you have a safe unit available and people meet the definition or the eligibility for an emergency transfer. Um, they also want to see that you know what your role is in facilitating an external transfer, how you're approving and denying those requests. They want to know that if you have a tenant-based rental assistance project, like a rapid rehousing project or a PSH project with a TBRA line item, that you are helping people move with their assistance if that's their preference. So if you have a tenant-based rental project, right? You could, in theory, also transfer the project by having them take their assistants with them and just moving them to a new unit. Um, and I guess just one thing to note during that is that if you are a TBRA project and you need to break a lease, right, because usually that's in the client's name, it is an eligible cost to use grant funds to pay for any amounts owed for breaking the lease if the family qualifies for an emergency transfer plan. So that's also something that you could add to your policy as needed, so you remember that. They're asking you to put in contact information at your housing provider for really who manages this process, who's managing all that record keeping we just went over, and to make some decisions around whether your housing provider is requiring documentation for an emergency transfer request. So you need to decide, are you making tenants ask you in writing for an emergency transfer or not? And then if you do get that request in writing or not, are you asking for additional proof of survivor status? You don't have to, but you can. And HUD has a self-certification form that you can use if your housing provider, if you've decided that you want that proof. Um, just know that you can't be requesting any documentation beyond kind of a self-certification unless you have conflicting information about the VAWA covered abuse. So maybe the other participant in the project says that actually the person requesting the transfer was really the perpetrator, and you need to kind of get to the bottom of what happened and see who's eligible for that request. That would be a time when third-party documentation requirements could come into play, but otherwise generally relying on self-certification. And I'll show you those forms too. So if you choose to have a participant submit their emergency transfer request in writing, HUD has made a model form for you to do that I'm putting in the chat. So your policies and procedures would say the request needs to be in writing from the client and it needs to use like this form. And you would adopt this HUD model form that I put in the chat for your clients to fill out to request their emergency transfer. I've put some of the updates that are listed on this slide here for the updates that are in 2025. So some of you might still be using the emergency transfer request form that HUD had previously given out. I would suggest moving to this form instead. I think it's a lot more clear and trauma informed because this form is no longer asking the client to put a bunch of details about the domestic violence, about why they don't feel safe in their housing. They're actually not asking for any of that anymore in this form. They're basically just saying, like what type of unit do you need? You're certifying that you need this request. Who is the perpetrator in this case? What unit size do you need? Where are you wanting to transfer from? And then there's a ton of questions about how to contact the client safely, including a comment box about any caveats that they may have. Another thing is that they added this caveat here that housing providers should not evaluate whether the client is in good standing in the project generally as part of the assessment or provision of approving an emergency transfer. So just because maybe someone has, you've been considering whether they need to be terminated or they're behind in rent, something like that, those can't be considerations in deciding whether to approve the emergency transfer. It's really just those eligibility criteria, and this form makes that more clear than the last form did. Does anyone have questions about the emergency transfer request form? Okay. Your specific emergency transfer plan for San Mateo County can be found in your governance charter, and definitely chime in here if any of you want to add any kind of local information. But your emergency transfer plan requires housing providers to have a compliant emergency transfer plan, which would include all the things we just went over. It does state that the ability to transfer must be available regardless of sex, gender identity, or sexual orientation. It reviews the documentation and confidentiality requirements associated with VAWA and emergency transfers. It requires housing providers to include VAWA compliant language in their leases, which we'll talk about. And then it talks about how it provides your collaborative applicant provides technical assistance about VAWA compliance. Anyone want to add anything about your local emergency transfer plan here? Okay. I know this is a lot and it's hard to make it exciting, but I'm hoping that you'll be able to go back through this and find some of it helpful as you're working on your plans and your compliance. Just quickly about confidentiality. Confidentiality is really paramount to making sure that we're ensuring survivor safety while we're trying to help them essentially flee during the emergency transfer plan process. And so we really don't want the perpetrator to figure out that they're trying to leave or learn where they're moving. And so that's why this new emergency transfer request form spends so much time asking how to safely contact the person filling it out so as to not impede their ability to move, flee, transfer. So you do need to make sure that you have strict confidentiality measures in place so that the new location of the new unit isn't told to the person that they're trying to flee from. So any information that you're getting from the participant when they're requesting an emergency transfer, including the fact that domestic violence occurred, should be held in confidence by you, the housing provider. And really that includes to your staff. So no one needs to know unless they really need to know to help with the actual transfer. And that includes the landlord. So I have up here when the kind of exceptions are to breaking confidentiality, but this is usually like a legal proceeding type thing, or if the survivor says it's okay to share the data. I think all of you know, right, the victim service providers can't put data into HMIS and need to use a comparable database. But a best practice here too is that the client is probably already in a mainstream database if they're, in HMIS because they're in a mainstream homelessness project. But that new location should probably not go in HMIS as a best practice without their consent. And maybe you consider having your victim service provider use a comparable database for that. Okay. I'm not going to go over this section too much, but I just wanted to let you know that there are some really cool charts here that the National Network to End DV has related to coordinated entry and how to share information with the coordinated entry system. So if you don't have a chart like this in your coordinated entry policies and procedures already, it gives some really nice advice about how to communicate confidentially with the coordinated entry system to get a referral. So the whole emergency transfer external process is predicated upon you needing to communicate with coordinated entry about a certain client, but without needing to identify them and sometimes without even needing to talk about the DV and getting a, referral for them. So they really just need to know things like what's their eligibility, how many rooms do they need, and when for that emergency transfer. So this is a general chart that applies to referrals, right? Because you won't need the assessment tool result, things like that for a transfer. But it's just a nice chart that goes over what information does the coordinated entry system actually need to refer clients and how do we protect client confidentiality for survivors. So just linked to that here so you can go back and look at it. The last section here on emergency transfers is that, you've done all of this work, you've determined if the client is eligible, you've figured out what forms they need to give you to ask for the transfer and how they show eligibility. We've talked about the mechanisms for the actual transfer, like internal, external, how to use coordinated entry. And then once you've completed the transfer, there can be additional practical considerations that HUD expects you to address in your policy. So a big one is what happens to the person left in the unit or to any household members that are left in the unit. And so those are decisions that the housing provider needs to make about how to handle those. So if a unit is vacant after an emergency transfer, rental assistance can terminate. And for TBRA, again, you can use funds to pay the landlord to break the lease in these emergency transfer situations. So if there are people still left in the unit after the transfer, you'll need to figure out whether you can continue to provide them support in the unit. And so it's possible that the landlord is already going to evict the remaining household member or members if they feel that they have violated the terms of their lease by engaging in criminal activity related to domestic violence. So sometimes you as the housing provider won't have an option to keep that remaining household member housed. You might also determine that you can't continue to provide assistance to the person remaining in the unit because you don't have the budget to do so. So if there was an internal transfer, for example, you may not have planned to serve two different households with rental assistance and you may not have the budget to do so. So you would need to work with the coordinated entry system to figure out how to continue to support that client or to get them a referral. You also might determine that the remaining family members aren't eligible to stay in the unit. So that's especially true if the person that transferred out of the unit was the qualifying household member, and I'll talk about how to figure that out. But overall, if you determine that you can't serve the remaining family members, you should work with the coordinated entry system on what to do about that. Before we talk about the eligibility of the remaining family members, I just want to highlight that you can also do a lease bifurcation. So say someone requests an emergency transfer and there are just no units available, they're waiting a long time and they decide that they are fine to stay in the unit so long as the perpetrator is exited from the unit. This is like a pretty specific situation where they're facing that imminent harm. This probably doesn't apply as much to the 90 days situation. But if they're okay to stay in the unit, you can request the landlord bifurcate the lease, kind of split the lease, and have the perpetrator removed from the unit instead of doing the emergency transfer if if you can't find a safe unit to transfer the person to and if the person is okay with it. Um, so, so just want to say that this is another way that we end up kind of with a remaining household members situation is sometimes we'll do a lease bifurcation to protect someone, and then that person that left or was bifurcated was the eligible and qualifying family member for that housing provider, and then you again have to figure out what do I do with these remaining household members. Um, so this gets a little bit complicated. So feel free to reach out if you're in one of these situations trying to determine remaining family member eligibility. But for rapid rehousing projects, tenant-based rental assistance projects, generally rental assistance can continue indefinitely for the family members who were not evicted or removed. And HUD basically says this is okay because these programs aren't relying just on one person's status or characteristics. They're kind of assuming that the entire family was likely meeting the definition of homelessness at the beginning, and that the assistance can continue. For permanent supportive housing, the remaining family members can only stay through the end of the lease in a TBRA project if they can't demonstrate their own eligibility. So they would need to meet the definition of chronically homeless or dedicated plus by the end of the existing lease in order to stay in the project. And if they can't, again, you'd need to work with coordinated entry on that rehousing plan. If you have a leasing permanent supportive housing project or other kind of non-tenant-based rental assistance project, remaining family members have 90 days to establish their eligibility for that project or locate other housing. So this is in the case of a lease bifurcation or an emergency transfer request, and you have remaining family members. That's pretty technical and hard to remember. So HUD did put in their notice of occupancy rights, which we'll go over soon, a big chart about remaining family members. They must have been getting a lot of questions about what to do about that. And so it is something that it seems like they're trying to address a bit more proactively. Okay, I promise we're almost done. This is the third safeguard of three for HUD's VAWA final rule, which are the notices and contract terms that are required to be given out to clients to make them aware of their rights. So first, we'll cover what notices need to be given to participants. And I will again put these updated forms in the chat as we're talking about them. So you all probably know that all households receiving COC and ESG funded assistance need to be getting a notice of occupancy rights and certification form when they're denied assistance, admitted to the program, being evicted, or being terminated from the program. So essentially, these are forms that tell the clients what their rights are. And so just like any other kind of fair housing or discrimination form, the client should get them so that when they're denied assistance, they know that if they're denied assistance based on a protected status, like their VAWA status, that they have a recourse. So they should be getting that notice at the time they're denied. When they're admitted to the program, they should be getting a notice about what their rights are while they're in the program. And same with an eviction or termination, they should be reminded of what their rights are so that they know that if they were evicted or terminated due to their protected status, what their recourses are. So it's very similar to how we hand out other kind of notices, like, do you think you've been discriminated against style notices? So the notice of occupancy rights really is that notice, and I've just put it in the chat. And it explains the VAWA protections that your clients have, including their rights to confidentiality, and then also the limitations on protections that we covered. So that notice really has everything in it that we covered in the previous slides about the core housing protection safeguards. The certification form, which I'll also put in the chat, is 5382. That form is the model form that clients can use to document that they're a survivor of, that's covered by VAWA, depending if you require them to fill out a form to kind of prove that. So this certification form is actually not required. So if someone is filling out an emergency transfer request form as part of your process, you don't have to ask them to prove their domestic violence status. But if you do have that process in place, this is usually the form you would implement, this self-certification form. that they would fill out to kind of provide that written proof of their status for you to grant that emergency transfer request. Um, and so if you're going to require this self-certification form, the rule is that you need to ask the person for a self-certification form in writing. So you need to request in writing for them to fill out the form I just put in the chat and that we'll review. And you have to give them 14 business days to get it back to you. Um, and so that's how you would make that request. They also can choose to instead provide you with third-party documentation rather than the self-certification. So someone might say, I'm not filling out the self-certification, but here's a professional statement or a court or law enforcement document or other document that your project would accept as proof of the domestic violence. So that's, I think, good to know, and also good to know that you don't have to give this form to the landlord or any of those documents that they give you to prove the DV. Those should be handled pretty confidentially. Um, One other thing for your COC to consider in its emergency transfer plan is whether you require proof that people are handing out these notices. So kind of similar to those lead-based paint forms that you have to provide proof that you're handing out, right? Like you give the form and the client signs a form that says, I received the lead-based paint notice, and HUD comes and audits you and looks for that form. Um, it's actually a local decision whether to require projects to keep proof that they're handing out these notices at all the right times in their case file. So HUD strongly encourages COCs to require this of housing providers, but you don't have to. So just another thing for you all to discuss locally is whether you want proof in the case file for an audit that these notice of occupancy rights are being handed out. So that notice of occupancy rights that I put in the chat was also changed in 2025. It now more concisely and clearly describes the rights under VAWA, and it went from 9 pages to 5. So I would suggest that you update your intake packet with this new HUD model form, because I think it is a lot more clear. It really describes the basics that we all already went over, which is when that you need to be giving out this notice, what VAWA is, how tenants can request an emergency transfer, and then it has a bunch of definitions and lists the HUD programs that are covered by VAWA, which include, of course, COC and ESG, but I think there is 15 of them here. So Section 8, HCV, all of that. It reviews how to access the form in a language other than English, and then it provides a link to do so that no longer works, unfortunately. So again, that kind of onus is on you to translate the forms now or otherwise provide language assistance. And then it still requires you to put in a bunch of agency-specific information into the notice before you can actually use it. So the notice tells clients that they can't be, denied assistance due to being a victim of domestic violence. They can't lose their housing due to domestic violence and the limitations of rights. It reviews lease bifurcation options. And then it again has that chart that shows what happens to remaining family members by funding type, since that changes based on TBRA, PSH status, leasing status, things like that. So you might want to update this notice and that chart that HUD has in there about remaining family members and just delete all of the sections about funding sources that don't apply to you. And just keep in the remaining family members section for like your very specific project and funding type to make it easier for the client to understand. Um, And then the certification has also been updated for 2025 that I put in the chat. So again, this form no longer asks about the details of the incident of domestic violence that the person is self-certifying that occurred. So again, recommend changing and updating your intake packet to include this certification instead of the old one. It makes the same changes as the request for an emergency transfer, asks a lot more questions about how to safely contact people, things like that. I'll do one more little poll here. So this is a notice of occupancy rights poll. When are COC and ESG funded housing projects required to give clients a notice of occupancy rights and certification form and select all that apply? Or wait, no, select one. When the household is denied assistance, admitted to the program, receives a notification of eviction, is notified of termination, or all of the above. Okay, so the answer is all of the above. We should be giving out these notices of VAWA protections at all of these times in the that are put here in the quiz. It's also a best practice to give this form out if you have a PSH project during an annual assessment. So really any time that you would be giving clients forms with important information about their rights and recourses is a good time to be handing out these forms. Okay. The last section is about what you need to put in your leases when you have a COC funded or ESG funded project. Most of you probably already have this language in your leases, so hopefully this is not new information to you. This section has really not been updated in the 2025 model forms, so less new information than the previous slides. But basically, I'll show you what needs to be in your leases. This is a lot of dense language, and you'll have these slides. But essentially, your lease needs to have either an addendum at the end, and HUD has a model addendum form, or incorporated into the lease language about what a client's VAWA rights are. So again, letting people know that they can't be denied assistance, terminated, evicted from their program due to their status as a survivor. And then also letting people know and having the landlord agree, right, that people have these rights, that an incident of domestic violence against the client can't be grounds for a lease violation, and it's not grounds for good cause to terminate the lease. They also are requiring you to add in language reminding people that they are required to get a notice of occupancy rights. And so this is actually super important in a tenant-based rental assistance project, like an RRH project, or if you have a TBRA PSH project, because the lease is going to be in the client's name with the landlord. And so how do you meet that notice requirement, right? We were saying that the notice of occupancy rights and certification needs to be handed out when a client is evicted. You, as the housing provider, are often not the one doing that eviction. And so in this lease language, you need to make it clear that when the landlord goes to evict this client, or if they do, they need to give them a notice of occupancy rights and certification when they issue that eviction. The landlord is probably going to be like, what? No. And so maybe instead you're making a process for the landlord to tell you about the eviction so that you can make sure that that notice gets issued at the time to be in compliance. If you don't trust that the landlord is going to compliantly issue that notice when they're handling their own evictions. Um, so this lease language is also making the landlord making the landlord commit to confidentiality and the recipient commit to confidentiality with any information that the participant has provided you about their VAWA situation, and is having the landlord agree to terminate the lease without penalty if the program determines that the participant qualifies for an emergency transfer. I think the most important thing on this screen, and it's good for someone like a housing locator to listen to this section, is if you have a landlord that you're struggling to negotiate a lease with, and they're like, I really don't want to add this VAWA language. It's not part of my standard lease agreement. I don't want to add this addendum. I don't really want to do this. Um, one kind of negotiation piece you can do is to only have the VAWA language apply to the lease during the period of time that you're providing assistance. So if they're signing a 12-month lease and you're providing 6 months of rapid rehousing, the addendum could have a term on it, right? That it only applies for those 6 months or for the duration of the assistance and nothing past that. So obviously that's less ideal than having it apply the whole time. But if it's the only way that you can kind of secure this lease and get it to be compliant, then that's a negotiation that you can employ. So strangely enough, HUD did not update its model lease addendum as part of its 2025 updates, and it no longer even has it on its website. So luckily, Homebase has it in its files. So the link I'm giving you is actually a Homebase link in the chat to look at the model lease addendum. Um, there still is a requirement to include all of this language in your leases if you have a COC or ESG funded project. And so again, I don't know why this form wasn't updated or is no longer included on the HUD website, or whether they expect you now to be writing your own lease language for inclusion. But we recommend still using the expired HUD model lease addendum, if at least in your leases. I'll put up my last poll. Are COC and ESG funded projects required to have VAWA language in all of their client leases, even those with private landlords? Okay, and you're all correct that yes, even with a private landlord, we need to have VAWA language in all of our leases. One thing to add is that of all of the VAWA compliance stuff that we just talked about, this is probably the easiest finding to get is this VAWA lease language finding, because when HUD comes to monitor you anyway, even if they're not looking for VAWA compliance, they are going to look at the lease that's in your case file, right? And they're going to look for things like, say in an RH project, was it for a term of at least a year? Was it only terminable by just cause? Does it have the month-to-month provision? Does it have any program fees in it? They're going to have a little checklist of like what makes a compliant lease for that audit. And one of those things will be the VAWA language. And so it's an easy thing to kind of get dinged on if you don't have that in your file, because they're going to be looking at your lease and an audit, even if it's not like a direct VAWA compliance audit. So it's something that they are probably more likely to notice than a lot of the other things covered today. So just an important thing to make sure you have. So this is kind of my end slide here about what we talked about today. I know it was a lot, so hopefully you can go back and look at this recording or look at these slides when you need additional clarification or reach out to us. But essentially, right, we learned today that we cannot discriminate against people experiencing domestic violence. We can't deny people assistance, terminate assistance, or evict tenants because of domestic violence related incidents. Uh, we need to have a written emergency transfer plan for all COC and ESG funded projects. The COC also needs a written emergency transfer plan so that we can quickly relocate survivors of domestic violence who are at risk of harm or who were recently assaulted in their units. We need to have strict safeguards about domestic violence survivor confidentiality. We need to have clear policies about when we're requiring survivors to document their status, and also recognize that there's limits on these requests about when we can ask for third-party documentation. We need to make sure that we're providing notice of occupancy rights and certification forms when clients are denied assistance, admitted to programs, terminated from programs, or notified of eviction proceedings. Domestic violence can happen to anyone at any time, so all clients need to be made aware of their rights in case there is an impact to them in the future. VAWA requires certain terms to be added to your agreements with landlords and your leases. We talked about the VAWA reauthorization of 2022 and the new protections in place there and the new definitions that they have. And then we went over the model forms and all of the updates that were made in 2025. And I advised you to look at updating all of your forms and policies in accordance with those updated forms. Anyone have questions or comments on any of that? Okay, and I think Garen has a poll here that he wanted to do, right, Garen?
I do. I think for whatever reason, the option to launch polls has disappeared for me. So Maya,
Oh,
I wonder
you
if
can
you'd be
launch it.
willing to do it.
Yeah,
Yeah.
maybe I stole your
Oh
I,
wait, I found
oh,
it.
you know
Sorry.
what? I just need to unlaunch this one. Sorry. I unlaunched, so maybe now you can launch.
Cool.
Yeah, we would love to hear from you if there's ways to present this material in a way. It's really hard to jazz it up. It's heavy compliance material, so um, yeah. Did everyone have a chance to get our email addresses, or should I keep putting up the slide here? I'll share it just in case. Do you want me to get off for this survey so that people can be honest?
Um, can you see the results as they're coming in?
No.
Okay. So, I mean, it's just yeah. I feel like people
Okay.
seem to be honest. I'm gonna stop the recording.